the tribunals in this lecture, and the main emphasis will be on the administrative tribunals. We know Article 323A deals with the administrative tribunals, and 323B deals with other tribunals, other disputes. It can be foreign exchange related, tax related, and other kind of tribunals, which I'll cover subsequently in the slides. It was 42nd Amendment which brought these two articles into existence, and it's a different matter that particular subclauses like 323A clause 2 subclause D and 323B clause 3 subclause D. I'll come to what these subclauses are. These were challenged in Supreme Court. So that is relates to L. Chandrakumar case, which is again very important as far as the tribunals are concerned. Now coming to the kind of questions which are relevant, which can come in descriptive type of papers. I have just listed few of the questions. You can just go through it at your leisure, again playing back the video. These are I don't want to read them out. These are just an indicative questions which can be made out of this chapter. Now, what we will cover, as I mentioned in this short lecture, I'll cover the 42nd Amendment, which no need to cover 42nd Amendment in detail for this particular lecture, but it was 42nd Amendment which brought these two articles into our constitution. We will cover L. Chandrakumar case, which is relevant. We will cover Article 32, 136, 226, 227 of our constitution because they are relevant with this L. Chandrakumar case. And we will briefly discuss about judicial review, which is a basic feature, or as it has been said in one of the judgment, it is inviolable part of the feature of our constitution. Now, coming to the articles, what are these articles basically? So, if we talk about 323A, it is basically about administrative tribunals. The very word administrative indicates it deals with service matters. So this article empowered the parliament. State governments were not empowered, the state legislatures were not empowered. Only the parliament was empowered to make a law, and this law could cover what? This law could cover disputes related to conditions of service and recruitment. If there are disputes related to conditions, service conditions, or the recruitment matters, then there can be a tribunal which may be constituted by parliament by law. So their parliament will have to make a law, and by that law only the tribunals can be constituted. Now this tribunal can deal with, you can have tribunals dealing with union issues, central government employees. It can also power is also given to the parliament to constitute tribunals for state. Like if certain state for certain state, parliament constitute can constitute a tribunal, or for a group of states. But the power to constitute tribunal and to empower the tribunals to deal with the service conditions and the recruitment matters, this power is only with the parliament. So that is an important part, unlike the other tribunal 323B, where the power is given to the competent legislature. Competent legislature will mean depends on the subject. So if it is a state subject, then it is only the state government which is empowered to make law on to empower to make law for creation of tribunal to deal with that subject. Now these tribunals will only cover public services, means these tribunals cannot deal private sector. Private sector is out. It is only for public services. This public service can be with union, it can be under state, it can be with any local authority, or it can be any corporation controlled and owned by government. So these are the bodies in which there are services, and employees of those services can approach these tribunals which are constituted under 323A. Now 323A subclause 2, clause 2, sorry, not subclause 2, I'll come to another subclause which is D. So 323A clause 2 basically empowers Parliament, as I mentioned, either to have tribunal for the union or for state or for two or more states. It also empowers Parliament to prescribe the powers for the tribunal, and the most important part is very clearly it says that power of contempt of court can be given to these tribunals. So the Constitution itself, in the article itself, it mentions that this power can be given to the tribunal. Of course, it is the law which will give this power, but this is the power which can be given to the tribunal. This is a very, very important part because giving power of contempt of court to a tribunal enhances its stature, enhances its role, and enhances its power. Now, the most crucial part of the amended articles, means the articles which were inserted 323A clause 2 subclause D, this was the most contentious part. This part basically, this 323A subclause clause 2 subclause D, means 323A to D. 323A clause 2 subclause D. This was contentious because it says the phrase of this is exclude, means Parliament while making law relating to the constitution of tribunals can exclude jurisdiction of all courts, means jurisdiction of all courts can be excluded barring the jurisdiction of Supreme Court under Article 136. We know Article 136 deals with what? It is SLP. SLP related matters, means it's a discretionary power of the Supreme Court. A special leave for appeal can be granted by Supreme Court. So only the jurisdiction of Supreme Court under SLP, that is Article 136, was allowed. Other jurisdictions were taken out. So what will be the other jurisdictions which will get affected by this law? If the law clearly states that under clause D that jurisdiction of all courts is barred, so you will you will be disempowered, or you will lose your right under Article 32, right to constitutional remedies. Means you can't approach Supreme Court for writs pertaining to Part 3, means your fundamental rights. What it can, what other things can be adversely affected? It will affect the power of High Court under Article 226, where it can issue writs. Not only for Part 3, we know that High Court has power to issue writs not only for fundamental rights but also for other matters. So that will get affected. And Article 227, these are High Court's power. Article 227, which is power of superintendence of High Court over all tribunals in its jurisdiction. So whichever are the tribunals in the jurisdiction of High Court, those tribunals are basically supervised. So there is a power of superintendence in the High Court over these tribunals. So that power also will get adversely affected when law is made using the powers given to the Parliament under subclause D of clause 2 of Article 323A. We'll come to that how it was challenged, but this is a contentious area and this is an important area. That is why I had done some elaboration here. Now coming to Article 323B, which is the other tribunals. These tribunals can deal with rent, can deal with foreign exchange, can deal with tax, can deal with land reforms and other matters. Here also you have under clause 3 subclause D, you have the similar provision of excluding jurisdiction of all courts except Supreme Court under Article 136. And unlike 323A, 323B actually empowers appropriate legislature as per the distribution of legislative and administrative relations in part 9. We know part 9 of the constitution, sorry, part 11 of the constitution deals with legislative and administrative relations. So depending upon the powers, appropriate legislature can make law and create tribunals for these areas. I just indicative areas I've taken. There are a lot many other areas where when you go through the article, you can discover. Now, proceeding further, coming to the important parts, there was challenge before the Supreme Court regarding the constitutional validity of the article. The challenge raised mainly three issues. One is it challenged the competence of the tribunals to test the constitutional validity, means the tribunal cannot we will not have the required competence to test the validity of the rules, of the various provisions of the acts, etc., made by the parliament. Then in this it was also challenged that you can't exclude jurisdiction under Article 32 to 226 and 227 because it strikes the very foundation of judicial review. You cannot exclude jurisdiction of Supreme Court or High Court. Supreme Court under 32, High Court under 226 and 227, which I have already discussed, and couple of other issues were raised in the challenge which was made in L. Chandrakumar case. Now, before we proceed further, let us have a brief look and recapitulate what are those articles under which the challenge was made. Article 32, as I mentioned, empowers it gives you a right to citizen. As a citizen, you can approach Supreme Court, and Supreme Court has powers to issue directions, orders, writs, and writs can be habeas corpus, mandamus, certiorari, quo warranto, and prohibition. So writs are these are the writs. Supreme Court can not only issue writs, it can also issue orders and issue directions when it pertains to any matter where your fundamental rights, which are provided in Part 3 of the Constitution, are violated, and you can approach Supreme Court. So this power was adversely affected by that amendment and the exclusion clause which is there in those two articles. Another article which we should discuss is Article 136, where there is a special leave to appeal by Supreme Court. This was not excluded, not excluded. So this remained. And what is this power which was not excluded? It is a most important part is it is a discretionary power. It is not that you approach Supreme Court under SLP and you have some kind of a right that it will be admitted by Supreme Court. It is a discretionary power, and it can be in any cause, in any matter, and of any court or any tribunal in territory of India. Just imagine, it can be on any judgment, decree, determination, order, sentence, any judgment, degree, determination, order, or sentence of in any cause, in any matter of any court of any tribunal in territory of India, excluding armed forces tribunal. In such cases, it is a discretionary power of Supreme Court to allow SLP. So this power I just wanted to discuss. It was not affected by the Article 323A and 323B. Article 226 was affected, and Article 226, as I mentioned, it empowers the high courts not only to issue writs, it can issue directions, it can issue orders pertaining to fundamental rights in Part 3 or any other matter. Actually, Supreme Court only has under Article 32 for Part 3, but High Court's power is much wider. It covers any other matter also. And the cause of action can be in whole or in part relates to the authority which is situated in the jurisdiction of the High Court. The physical physical location of that authority is not required, but if the cause of action lies in the jurisdiction of High Court, then High Court can intervene in the matter. This direction, order, or writs can be issued to any person, to any authority, or appropriate government. So these are the three broad bodies which can be covered by the directions, orders, and writs of the High Court. This is a very wide power of High Court. It would have been adversely affected had the constitutional validity of Article 323A and 323B not been challenged. This is another power of High Court which was getting adversely affected, that is power of superintendence over all courts and tribunals in the territory of the High Court. Territory in relation to which it exercises jurisdiction. We need not go into that much of detail. Again, the armed forces tribunals are excluded. Now coming to this again, this power of superintendent of High Court was getting adversely affected. Now what did Supreme Court say in L. Chandrakumar case? I am just briefly mentioning the important points. One is that the jurisdiction of Supreme Court under Article 32 and High Court under Article 226 and 227 is part of inviolable basic structure. Inviolable is the word, very important. Inviolable means this basic structure cannot be disturbed at all. So this jurisdiction just cannot be taken away. It's part of inviolable basic structure. So accordingly, having held this as a part of inviolable basic structure, the subclause D of both the clauses, means 323A2 and 323B3, they were declared unconstitutional to the extent that jurisdiction of Supreme Court and High Court under Article 32, 226 and 227 were excluded. So if you say very clearly, the language is unconstitutional to the extent in which it excludes the jurisdiction of High Court and Supreme Court, means the jurisdiction of other courts can be excluded. So it is only the jurisdiction of Supreme Court under 32 and High Court under 226 and 227 which cannot be excluded, because it is one inviolable basic part of inviolable basic structure. The court also said that any law which has been made exercising the power under these clauses will be void, means will not remain, will be void to that extent, means to the extent it was affecting Article 32, 226 and 227. This is important. The Supreme Court acknowledged the supplemental role. So it was not that the tribunals will replace the high courts, which was the real intention, was to expedite. That was the stated objective, was at that point of time, was to expedite the administrative matters. So whole thing was being given to the tribunals. So, but the Supreme Court said that the high courts and supreme courts cannot be excluded, but the tribunals can play a supplemental role. So this is important. So tribunals have their own place in the entire scheme of things of administrative jurisdiction, administrative disputes, and they play a supplemental role. But the decisions of the tribunal will be subject to the scrutiny of division bench. Division bench is not single bench. So it is division bench of High Court. So these are some of the important areas related to the tribunals which I wanted to cover. Thank you.